Everyone, and welcome to the American Enterprise Institute. This morning's forum is, we welcome our live stream audience with us now. This is America's Obamacare's administrative law space, navigating the next frontier. I'm Tom Miller. We're going to have three different panel segments today. We're going to start off by taking a look at the legal legacy of Obamacare as implemented and administered by President Obama and the executive branch over the last 8 years, and there have been some disputes and conflicts over what was and wasn't proper or legal, or what maybe had to be done. For that, we have two panelists this morning who are fine ones in this field. Josh Blackman is an associate professor of law at the South Texas College of Law in Houston. He specializes in constitutional law. He also recently specialized in writing books about Obamacare. First one was unprecedented in more ways than one, but that was the beginning of the title. And then the second one more recently was Unraveled, and for all promotional and considerations, as they say, there's the book that you can find at many places. And I review these books the way everyone in Washington does. You look in the index and see how often your name is mentioned. Not quite enough, but enough to say it's a pretty good read, is the way I tend to look at those things. So in addition to Josh, we have Joel Ario from Manat Health and many other places as well. He's been a very experienced state and federal regulator. He was the director of the Office of Health Insurance Exchanges at the U.S. Department of Health and Human Services. Later got relocated to CMS for budgetary reasons. And that involved a lot of figuring out we got the law now, what does it actually say and how do we put it into practice and write some rules and guidance for that. And at the state level, Joel has experience as being an insurance commissioner both in Pennsylvania and Oregon. So we're going to tee each of these gentlemen up for some opening segments, and then we'll have a little bit of an interactive panel discussion. So Josh, go to it.
Thanks, Tom. I know all of you want to see me on a Monday morning, but here we are. I'd like to talk about a phenomenon known as government by blog post. The ACA during its implementation was modified, delayed, and suspended in ways that cannot be justified by the statute. During this period, the Democrats did not control both houses of Congress as they did when the ACA was first enacted, so it became very difficult for the president to enact his agenda legislatively. I want to talk about three primary actions that were taken during the 2013 summer and fall that reflect how the ACA was modified. The first concerned the employer mandate. The ACA basically says if you are a business with more than 50 employees, you are required to give your employees insurance, and if you don't, we will penalize you. Unsurprisingly, businesses didn't like this very much. So throughout 2013, a lot of businesses came to the president, hey, look, we can't handle this. This is too much for us. The president says, you know what? I hear you. So during the summer of 2013, the president issued a policy through his administration saying we are going to delay the implementation of the employer mandate 1 year. The excuse was, well, we're not ready to do it. The Treasury Department can't handle it. There are all these forms. We simply cannot do it. But that wasn't the only change that was made. Later that year, another change was made. Not only was it delayed a second year, but it was modified. Depending on the size of a business, they were required to keep a different level of employees insured. None of this at all can be derived from the statute. They basically created a new mandate, different from the one that Congress drafted, for the sole purpose that businesses didn't want to have to pay for it. Perhaps I believe that this delay was due to administrative concerns if it lasted 1 year, but after the second year of this modification, I'm not quite so persuaded. The second change I'd like to make reflects something that we should all know a lot about. Congress plays by different rules. When the ACA was being drafted, Senator Chuck Grassley of Iowa, who's a fiscal hawk, inserted a provision that said that members of Congress must get their insurance through Obamacare. That is, through a plan created under the ACA or the ACA exchanges. The thinking was simple. If Congress is on Obamacare, it will be better because Congress won't give itself something that's bad. This provision was not popular among the Democrats, but was put into the Senate bill. And then, as we all know, because of the Scott Brown election, that became the final ACA. The House could not make any changes. So they basically accept this provision. But if you think about it, there's a problem here for Democrats and their staff. If you are a member of Congress or a staffer, you get a massive subsidy for your insurance. So things like 75%, right? Regardless of your income, you get a huge subsidy to make insurance more affordable. If you're a regular Joe Schmo in the street and you're earning a congressional salary and you have a family of, say, 2, you will get zero subsidies from the Obamacare exchange. So you had en masse both Republican and Democratic staffers rebelling and said, oh my God, if we lose our subsidy, we're going to resign. We cannot handle this. So what did the Obama administration do? More government by blog post. So this is actually very intricate, and follow along. The District of Columbia has something called a small business exchange. So here's what happened. The government said, okay, we will deem Congress a small business, okay? And we will allow members of Congress to buy insurance as if they were on this small business exchange. It's an Obamacare plan. And oh, by the way, we will give the exact same subsidy we gave before to this new small business exchange, which no one else on this exchange receives. Now, mind you, Congress is in no sense of the English language of small business. And to make the point even more clear, the statute says 50 people or less. Congress has like 20,000 employees. And they say, well, each office of Congress might be a small business. No. The Speaker has almost 100 employees. So in no sense can this be a legal move. But who's going to stop it? Senator Ron Johnson of Wisconsin filed a lawsuit to challenge it, but as we all know, there's no standing. This is a brazen illegal change. You want to hope President Trump reverses. You want to drain the swamp? Kick Congress off their health care. I'm serious. This will be the greatest impetus to spur change. Say, hey, we will throw your staffers off their insurance. You are getting illegally. Talk about Anti-Deficiency Act. This is illegal. The third change I'll talk about before Tom throws me off the stage with a vaudeville cane is the individual mandate. Now, we were told in the first Obamacare case that the linchpin of the law is the individual mandate. This is what makes the entire thing operate, and without this mandate, the entire Obamacare will fall apart. Not exactly. During the fall of 2013, the president's promise, if you like your plan, you can keep your plan. This promise came to be known as a lie. In fact, it was dubbed the lie of the year. Why were plans being canceled? Because Obamacare said we're going to make it hard to grandfather new plans. All these regs issued about grandfathering and minimum essential coverage made it harder to keep your insurance. So this was an absolute lie. But how did the president react to it? In Congress, there were various bills, bipartisan bills, that would have allowed people to keep a plan for one more year. Did the president sign those bills into law? Of course not. He threatened to veto them. Why? Because he wanted to do it himself. He was afraid that if you let Congress modify the ACA, they may modify some other stuff. That's how government works. But instead, he issued a series of executive actions letting people keep plans that were not valid under the ACA. What was the legal basis for this challenge? A hardship. What was the hardship? Obamacare. The ACA has a hardship exemption, but here the hardship itself was that the law made insurance too expensive to afford. If that is a hardship, then the entire damn law is a hardship, which cannot be the case. Even worse, these changes were unlawful. They shifted to states this burden of deciding, do you want to continue offering these policies which are contrary to law? Some states said yes, some states said no. These actions were challenged in court by West Virginia, among others. What happened? As you know, there was no standing. These cases were tossed. In case after case after case, you can read my entire 600-page book, the ACA was delayed, modified, and suspended in ways that cannot be defended on the basis of the statute. The only basis of these changes were that it was inconvenient, and people weren't happy, and the president wanted to make the law work for everyone. Now, looking forward to the next administration, those are the same things. I'll be here screaming, doing it legally, right? We need to have a rule of law. We need a terrific rule of law, a beautiful rule of law, and one that people can follow consistently. You cannot modify statutes on the fly through executive actions without serious repercussions. Thank you so much for your attention. I welcome my esteemed colleague to provide his take. Thank you so much.
Now, Joel Arrio is not exactly a neophyte in this area. He's actually had to deal with this up close and personal and go through. They hand you a law and they say, we want this out the door, and it's going to be a tough minefield to go through. And although Joel is going to speak from the background of a regulator with practical experience, you're not a neophyte in the law area either. He got a law degree some place called Harvard, so he could probably wing it on a final exam if necessary. But Joel, why is it that the people who are so critical of this, they just don't understand? What were you facing, and what did it really involve, moving the Affordable Care Act from the law that Congress passed to the one that would actually work in the field?
Thank you, Tom. I'm happy to answer that. First, I got to make one quick comment, Josh. Listening to you about the president's promise and the lie of the year, I'm very thankful that Donald Trump is saying that we'll have a smooth transition and everyone's going to get better coverage at lower costs. So we'll see whose promise this year is on the lie of the year list next year. So what I did learn in law school, I didn't learn any real specific law. I did go to Harvard, so I just learned a lot of theory. But one of the theories that I learned that I've always kept with me as a regulator was the three different ways to think about the sources of legitimacy for administrative law. In the beginning, back in the 20s, the theory was literal application of the statute. You couldn't do anything beyond the four corners of the statute through an administrative agency. I suspect a lot of people in this room say, as Josh did, that we ought to get back to that more than we've kind of wandered from that some, not just in this administration, but in others. I have some experience with that. I've been told more than once by a legislator, we make the laws, you execute the laws, and so there's very much a grounding for that kind of perspective. I have to tell you though, in the real world, I've been told much more often by legislators, thank God you guys are there to save us from what we wrote in that statute. The way the process works, we leave things ambiguous on purpose. I used to think it was mistakes, like how could the statute not answer this question? Now I know that most of the time it's an intentional act by the legislative body because they can't resolve that issue and get a bill passed. So I'll just tell you, in the real world, I've been told more often than not, thank God you guys are there to make the law work better than we were able to write it in the first place. That's just fact. Second theory, though, of administrative law comes from the 30s, expertise model. It's a little unwieldy when you start having more laws like the Roosevelt and the New Deal. And so you have this model of, well, the administrative agency has the expertise to do things that the Congress or the state legislature may not know as much about. And that's deeply embodied in the ACA. One example all over the ACA is we're going to consult with the NAIC, the National Association of Insurance Commissioners. They'll figure out how to answer these specific questions. We're essentially delegating to a model of expertise. And that plays a big role. I have always, in my time as a regulator, wanted to consult with the experts and figure out how best to implement things if they were in charge. But long about the 60s, another period that's sort of like today, where people sort of say, not only are you entitled to your own opinion, but you're also entitled to your own facts, and everything's relative. So this model of expertise and objective, truth didn't really sit well necessarily in the 60s. So you get this third model, Stewart, a former law professor at Harvard, of public participation or mini democracy sort of. The administrative agencies are doing something closer to what Congress is doing. So the way to protect the public is to have a lot of process, due process around the way regs are developed, public comment periods and so forth. And I will submit to you that if you look at the process we have today, that's the sort of more dominant paradigm than any other one, as people sit in the councils of these agencies like I did, try to figure out what to do. You definitely look at the statute for your touchstone. You also talk to the experts about what makes the most sense, but ultimately you say, we really got to figure out where the different constituencies are and how to, execute on this law in a way that works there, and their public comment and all of that, formal and informal, to get to the result. So how does that all apply to the ACA? I'll give you two examples. Earlier, I wasn't there when Josh was there for the examples that Josh gave, but I'll give you two back to the start. The essential health benefits. Secretary shall define EHBs. That invariably people who I spoke to everybody across the board that were cynical about this law would say, Joel, wait till you get to the defining essential health benefits. That's when you'll find out what a fantasy this law is and how impossible it is for some group in Washington, D.C. to define benefit structures uniformly for the whole country. And I would always smile because I knew right from the very beginning, we knew that wasn't going to be the model. It wasn't going to work that way. The states had a lot of experience at defining essential health benefits, and they were going to be the ones to make these decisions. The secretary came from state insurance regulation. I did. A number of the other folks did. So what ended up happening there, in Congress, by the way, you couldn't do a little application of the HB rule, right? The Congress knew they couldn't do it. They didn't define them in law. Clinton had tried that. Didn't work. So it just said, secretary shall define. We knew if we gave it to the experts, we were going to get either something that wasn't workable or something that was too rich to make sense under the law. It was already, as people know, pretty high level was the way the essential health benefits came out. So it was really that third model of a process, and we basically put it back to the states and said, you guys are experienced at this, you guys have to define it state by state. We'll create some touchstones for you. We'll say that you have to pick from popular plans. You have to pick things that people in your state are actually buying. So there are like 3 choices of what the state could choose as their model for essential health benefits. I will submit to you that there is no practical way to do anything other than that basic course, and that we won't see a different result here. If anything, we are going to see now even more delegation aggressively back to the states around those issues. But that is how we handled it. And the other issue, again, I'm trying to keep, Josh kept the time, so I'm going to keep to time and be real.
You'll get some
quick.
time to talk between yourselves.
Real quick on this. Second one is the exchanges. Their formation of the exchanges, state exchange versus federal exchange. Their statute could have been applied literally. It said the secretary shall decide whether a state is ready by January 1st, 2013. We knew long before that if that standard were applied literally and we only let states through the door that were fully ready, there weren't going to be many states getting through the door. But we also knew that the states, because of political participation, many of them wanted to do something here. And so that statute, which could have been interpreted literally, there was really no expertise model to apply to that decision, but political participation, kind of public participation, suggested that we ought to let states have more of a continuum of options. And I will submit to you, I'm very prouder of that set of decisions than any that I was involved in at the agency. We said states ought to have different models. No state is going to be completely federalized. By the way, some people think today many states are completely federalized. They're not. 45 states have applied for and received certification to review rates, one of the most sensitive issues. 45 states do their own rate reviews under the ACA. And many more states do other kinds of plans, many less states, I should say, but more than half do some form of participation in how the insurers are certified for the exchanges. Only today, a dozen still have basically full state exchanges, and even they depend heavily on the federal government. So there's a whole continuum of options there, which again reflects reality. And it just, so I'll conclude. I'll make one last comment. I was going to do something about your stuff, Josh, but this is the last comment. King, I got to get a point in about King. One of the most helpful things to me to understand the election result here has been, and I'm sure most people in the room have heard it by now, the opponents of Mr. Trump listened to him literally and didn't take him seriously. The people who were supportive of him took him seriously, but not literally. He wasn't going to build a wall, but he meant he was serious about putting some brakes on the immigration. I will submit to you that Justice Roberts when he actually had the pen and was in charge at the Supreme Court and looked at that King case and said, everybody who knows that case, Scrivener's error. That's what we had, a Scrivener's error in that statute. And he, to his credit, said, I'm taking Congress seriously, not literally. And in the best sentence in that case, he said, Congress wrote this law to improve the healthcare markets, not to destroy them. And he knew that would have been the outcome if he'd taken them literally.
Well, many of us
Lord
were
help
willing
us
to.
if Donald Trump's in the Supreme Court. Lord help us.
I was just going to say, many of us were willing to stipulate that there were plenty of errors in the way the law was written, but that may be involved in different
I said
range of issues.
Scrivener's.
I understand, but they had to write it eventually. Josh, in the beginning of your rebuttal or follow-on, was this just business as usual? I mean, get over it. Congress makes a few suggestions, and then the wise folks in the agencies make the silk purse out of the sow's ear.
Nancy Pelosi gave one of the most famous comments ever. We'll pass the law, then we'll find out what's in it. People didn't actually understand what she meant. She was actually correct. Joel's right. So much of the laws of the secretary shall do this and the secretary shall do that. Congress gave effectively a blank check to the agencies to do a lot. This is a dangerous form of lawmaking with a law that affects such a significant portion of the U.S. economy. But the fatal conceit, if I may say this at AEI, was the supposition that after the ACA was passed on a straight party line vote, everyone would simply fall in line and everyone would sing Kumbaya and hold hands and think, okay, how can we best implement this statute? Instead, Joel was stuck implementing this law under sniper fire from all directions, like Hillary on the tarmac, right? This was some very serious business. And there was such political opposition to this law that it became almost impossible, right? For example, with this January 1st business, right? And in a Congress that liked this law, they'd pass a one-sentence bill saying, okay, we say January 1st, we meant actually the following year. The employer mandate, okay, businesses aren't ready, let's pass a statute, fix it. If you look at how LBJ implemented Medicaid, if you look at FDR implemented Social Security, Congress worked to make tweaks to the law. And that was a supposition of how this would operate once it went past the hump. It didn't. The political animosity to the ACA was so virulent that there was no prospect of getting sort of legislative fix. So instead, the agencies had to turn to bizarre readings of statutes that could not be grounded in the text for the law to save it. And this, I think, is an unfortunate aspect that healthcare law, something I think is important, has now been politicized, so much so, the Republicans expect it even worse, right? This is such a politicized topic that's going to be very difficult to get any sort of bipartisan consensus on what to do going forward.
Well, Joel, to throw you another lifeline that you don't need, it's a little different when you really can't make, I assume, the technical fixes or the adjustments. You've got the law that got out the door, as opposed to the one that might have gone through a conference committee, been ironed out, might have had some technical corrections in a go-around. So when you're facing that, and you also have, real-world political and practical pressures, you've got deadlines to hit, things have to eventually move. Was this any different in stretching the boundaries and filling in the gaps than what you've seen in general in this space?
Yes, because of what Josh said, that it got so partisan. But there's a lot of revisionist history being written about where that came from. Initially, when I got there in August of 2010, this law had still a bipartisan veneer, even though it had been passed only on Democratic votes. I walked into an office where 49 of 50 states, every state except Minnesota, surprisingly, had petitioned the federal government for a grant to set up a state exchange.
That was receiving money, though. That's a little different.
Well, but still, they'd gone and applied and said, we want to consider this. And Pawlenty made clear the political objection to that. He opposed it on political grounds. He was going to run for president. And his party lost the next election. Minnesota petitioned. So all states were in initially. Then the 2010 election came and people saw the results. I remember getting a flood of emails the next day. We're in trouble now. And basically that was when the Republican Party discovered that opposing this law, saying we're tooth and nail against this law, is good politics. And basically we kept saying, when is this going to stop? It only got worse, and it's still probably getting worse. I'm old, and I'm more of a bipartisan guy now. I lost a lot of my partisan edge. I really, really hope the Republicans don't make the same mistake. If they pass their replacement on a strict party vote, and remember, the Democrats worked pretty hard to get Chuck Grassley and all these people. I'm sure they're going to work hard to get them, but if in the end of the day they say, because they're not dealing in good faith and so forth, we're just going to go ahead and do this on a party line, they will pay exactly the same price. That's how our politics are. I don't know how we get out of this cycle, because then the Democrats, next time they get control, will do it. So somewhere someone has to have the sense that it wasn't good, even though there's all these arguments about how the Republicans didn't play fair, to try to do something on a strict party line vote. I hope the Republicans have learned that lesson, but that's what made this more difficult and harder, because you had every decision here being exposed to people looking for the opportunity to attack it rather than feeling ownership. And there's all kinds of things, the 3 Rs and all kinds of things under this law, where the Republicans are just fine to do generous things, how we call them, for the insurance industry to stabilize markets. They call them one thing over here, and then over in the ACA, they don't like them. So there's all kinds of ways the parties could get together if they had incentive to be together.
There's a lot to be said for new definitions and new acronyms for essentially the same thing, and that's been attempted before, even at the agency that runs Medicare, as I recall, years ago. If you can't solve the problem, change the name. But Josh, and I suppose we always have the urge to relitigate some of the cases like King v. Burwell, which, as far as I can tell, I think that one's in. And Joel was suggesting maybe a different form of accountability and checks and balances, which are in the political sphere, although I'm not sure whether the orbits or the Venn diagrams intersect as opposed to staying where they are. Can we go to the court? I mean, there's been efforts to go to the courts on these different items. A little bit of a checkered history. Is that an effective policing mechanism, or does it require something way out there and also threading the needle of can you get a case? Can you get it all the way through?
Chief Justice Roberts breaks my heart every June, without fail. He finds one way or the other. In NFAB Sebelius, he broke my heart with the saving construction. In King v. Burwell, he broke my heart with this we have to save Obamacare, right? SCOTUS care, as Justice Scalia called it. The courts have not been an effective means of checking Obamacare. And as much as I think these cases were correct, that's probably the right answer. Perversely, what will it take to kill Obamacare? It wasn't John Roberts, it was Donald Trump, who has pledged to rescind Obamacare. Perhaps that's what John Roberts wants all along. Let the Democratic branches resolve it. I think his analysis is indefensible, but that may be what was motivating his decision. Let Congress take another stab at it before we strike it down. But I think the long and short of it is that there has been a cost, right? Reading these Roberts opinion, I don't think anyone takes him seriously, except for maybe Jeffrey Rosen and a few other people, right? No one believes this is actually a legitimate form of jurisprudence. If the chief actually meant what he said, he wouldn't spend 30 pages talking about the commerce power because it was irrelevant. If he actually meant it was a tax, he'd actually address the direct tax argument, which he simply glossed over, right? If he actually meant what he said about the text being strong, King v. Burrell, he probably would have ruled Justice Scalia. This wasn't a Scrivener's error. If it was a Scrivener's error, the government would have lost. The SU was very careful to say this is not a Scrivener's error. This was a deliberate choice. And say this was a deliberate choice never made any sense. So there's a cost to trying to save laws with these ludicrous interpretations of the statute, because some people become cynical, right? He's not calling balls and strikes, moving home plate around. I think it's a very dangerous way for the Chief Justice to act.
Is this we're looking at the back end, whether who wins or who loses at the polls, or whether you can intervene after the fact legally? Does this start earlier in the process with what Congress tries to do and what it can actually accomplish? Would we be better off with a one-page law saying, here's a lot of money, go do some good things, and we'll see how it turns out, and fill in the blanks there? In other words, how far have we moved from what might be a more active involvement by Congress in a difficult political age to say a little bit more as to what the real parameters are? Or is it just such a huge overlapping, expansive area that you really can't put this into legislative text, and we are going to defer to the people who are appointed to reinterpret it?
Well, I strongly believe that you can't, in our society, do either the legislative job, the executive job, or the court's job, for that matter, on a literal application of everything. You have to have these other models in play because we are too complicated a society. But in that sphere, I would say that a Congress writing shorter laws that are clear on goals and purposes and leaving more to the executive branch of to the administrative branch of the detail is the right model for it. Secretary Sebelius once said about the law before it was passed, I hope that we write a shorter law, because if we get the basic principles down in the law, then the next thing always is, well, where are the unintended consequences and who's going to try to game this system? And then we try to write, another 10 pages for each of the major provisions to deal with that. And then we've not really done it. We've only created another 10 pages of unintended consequences.
Well, I always love it that the first 500 pages of regulation doesn't quite get the job done, and we come back at that as well.
But if you keep putting more down, you just keep creating more unintended consequences, I believe. So I am for the more simplified models. And Josh, I know on your, some conservatives like to say this is a cheap shot, but I don't think Brown v. Board of Education, which was not a literal application of anything there, was a bad decision. The court's best decisions over history have tended to be ones that do take the temperature of the country in an effective, helpful way. And it's interesting now, because I've been predicting this for a long time because I've watched the courts over time. It used to be judicial restraint meant don't interfere with the congressional branch. Let the congressional branch do what it wants. Now, as the conservatives, give them their due, are going to get more and more seats on the Supreme Court, it's not going to mean that. It's going to mean this activist thing, which it's meant in most of history. The courts that are activist use their own theories of they call them constitutional theories on both sides, but they're actually a different theory than what's guiding the majority in the congressional branches. And so we're going to see activist government, and we're going to see the liberals start to talk about what judicial restraint means is let the Congress make the laws and you execute them, and we're going to have the courts all the time imposing their activist definitions. And the conservatives, like they have through history, back to the 30s, are going to be the ones that are going to bear the brunt of Democratic pushback on that exact theory.
Josh, this just sounds also reasonable. We don't want those extremists to run wild. Was there something going on here that maybe jumped the rails beyond the usual process? What's really, do you see something essentially different here as opposed to same old, we lost in this case, they won in this case, but it's really just partisan fighting and bickering around the edges? Or is there anything deeper in terms of where we've traveled as a result of what the Obama administration has done?
I think you really need to read a careful study of Justice Scalia's dissent to King v. Burwell. This was his last oral dissent delivered from the bench. And he had this very profound comment where he said, maybe one day the ACA will become like the Taft-Hartley Act, right? Or the Social Security Act, these landmark pieces of legislation. And maybe at that point they'll have such gravity that courts should give that extra oomph of deference to the state because of this sort of entrenchment. For reasons that I'll never know, the Chief Justice decided that from the moment it was enacted, before a single person even gained a health insurance policy from it, this was a legislation of such enormous stature. And as a result, he would bend and twist and do every type of gymnastic you can imagine to find ways of upholding it. Why? Who knows? We got Kennedy, right? You actually get Kennedy on a case and you still lose. That means you're in trouble. As for the shibboleth of restraint and activism, these are labels, right? Activization is a position you don't like. It can be used to describe anything. I'm always been in favor of what's called judicial engagement. If the thing's unconstitutional, strike it down. But the courts are not going to be the avenue of killing this law. My first book was called Unprecedented, which focused on a challenge to the mandate. My second book was called Unraveled, which focused on Hobby Lobby, Little Sisters, King v. Burwell. My third book, I don't think will have much about the courts. I think it'll be a process of legislative battle. If it indeed is a bipartisan vote to kill it, it's going to be just as bad. I think Joel's 100% correct on that, and I've written that exact point. But at this point, the courts didn't do it. Okay. So now we have an election where there's a Republican, he calls himself a Republican president, and there's Republican members of both the House and the Senate. And in the 2018 election, we may get actually 60 votes for Republicans in the Senate, and in which case you can probably kill the entire law. This is why the repeal and delay thing, we'll talk about later, may make more sense. So the politics will take care of this. It didn't get a consensus when it was coming in. There's no consensus now, and who the hell knows what will happen next.
Judge, this idea that you can't tell what judicial restraint is pretty easy. Judicial restraint is not making the court the center of attention and changing the dynamic in the society.
No, it's when we win and they lose. That's how we define it.
No, it's not. We know Roe was a judicially activist decision. If he'd gone the other way on King v. Burwell, trust me, he would have been seen as a very activist judge. He did old-fashioned restraint, and Scalia practices it too, by the way. One of my favorite Scalia moments was in Bush v. Gore, where he was trying to argue that the Florida Supreme Court was interpreting the statute wrong. He was trying to stick to his literalism. He couldn't get 5 votes on the Supreme Court for that proposition. So in order to make Bush president, he said, you know what, I'm going to have to hold my tongue and join O'Connor on a due process argument that he would never apply anywhere else. But to get Bush to be president, by God, he was going to join O'Connor. So everybody has both sides of this at different times.
We're starting to jump the rails, but let me try to wrap it up this way before I go to our next panel, because we did come here, at least nominally, to talk a little bit about the law, even though that ends up being politicized and stretched in many directions as well. So the wrap-up comment before we move on to our next group of folks is essentially, in your own view, what's the aftermath? What's the legacy of what was done over the last 8 years in terms of whether it's the state of administrative law, what's going to happen in the future? Is it just a clever, pragmatic rescue job, or did something stretch beyond where we'd been before? I'll start with Josh.
Adrian Vermeule, who's a law professor at Harvard, has this great metaphor. You've all seen the Jane Austen novels made into movies, right? Where you have these 2 lines of dancers, right? And at the moment they switch lines and you see the exact same moves on the other side. I think that's what we're going to see. Joel alluded to this before. For the last 8 years, conservatives have said we have to get rid of Chevron. We have to constrain our. We cannot have these agencies running amok. And liberals said, no, 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 no. Trust guys like Joel, right? Trust guys at HHS. Trust the Office of Civil Rights at the Department of Education tell schools how to manage their bathrooms, right? Trust these guys. Okay, now the shoe's on the other foot. Now we're going to have conservatives making decisions about immigration, civil rights, a host of other things. And they'll say, no, no, no. We need courts to be skeptical. We need courts to second guess. From my perspective, I like skepticism generally, right? I'm happy to work with liberals to establish doctrines that pare back the administrative state now, because eventually there'll be a Democrat in office, and you can make principles consistent, neutral principles, as Wexler may have called it. We're going to see this very quickly, and even in this GG v. Gloucester County case, not an Obamacare case, but a case involving what's called our deference, we will learn very quickly where people stand on administrative law.
Yeah, it's interesting you say trust people like Joel. My experience of moving, I started as a Ralph Nader guy in the public interest research groups, and I came to insurance regulation 25 years ago thinking that my job was to kind of go in there and with a head of steam and bring the plans to heel and all of that. And I have learned an awful lot over 25 years. And most of it has to do with you better listen to the insurance companies as carefully as you listen to everybody else. And you better be very humble about what you do. And you better never buy one particular theory and never get too strong and too arrogant about one way of looking at the world. You better mix it all up and in this context apply literal application and expertise and democratic process to figure out the best result, and you better not have your ego in it, and when you do, you are likely to make the wrong decision. So I think you got to have Congress, you got to have the administrative agencies, you got to have the courts, and if they all practice some forms of restraint and collegiality. But I do fear that the partisanship has been so unleashed around this issue, and maybe it's inevitable when you make this big a change in society to move us towards a safety net. I do think the conservatives are right that if they don't roll back this safety net, we've moved a step more towards a kind of social welfare system that's different than what they want. So there's big issues to be fought for, but I hope we can get rid of the partisanship and find some American solution that doesn't keep us jumping back and forth in the two sides switching roles every 8 years.
Keeps us busy in the punditry. We're going to change hockey lines on the fly. We're going to keep Josh and Joel in the penalty box over here and bring up. You have to stifle yourself till the third segment. So if our other speakers can come up, we're going to have Adam White, Dan Menon, and Daniel Hemmel just filling in the chairs there. Or you can excuse yourself a minute. Okay, turn your mic off though while you're walking around. We're going to get now a little bit more technical. This won't get you continuing legal education credit, but it might move in that direction, which is we're really going to just leave a little bit of the Obama administration history and pros and cons on that behind for the moment and talk about what we know, what we don't know, what we think about what the law actually allows, permits, what are the tools involved here. And we've got three folks who are deeply experienced in this area. I'll each introduce them separately as they speak. We're going to start with Adam White, who's a research fellow at the Hoover Institution, writes about the courts of the administrative state for many publications. But before Hoover, he was also in legal practice at Boyd & Gray and Associates, wrote a few briefs, with which I'm occasionally familiar on different aspects of that, and beyond just the healthcare space, and also, like most of the folks here, have clerked and done all the other stuff that smart lawyers tend to do. But what I asked Adam to start us off with was to take a look at the toolkit for a new administration. They come in with great dreams and hopes and say, what have I got I can use? And maybe they might not be patient enough to wait for the legislative process to grind along. So leaving aside what may or may not change in what Congress does, if you just wanted to go about changing what was before to what you want in the future, what would you have available to you? And there's a wide array of possibilities. Adam, go to it.
Sure. Glad to be here to talk about the lawyer's toolbox. And I just want to say at the outset, in terms of being here, This is my first chance to speak in the new AEI, and I'm reminded of the quote from Churchill, "We shape our buildings and then our buildings shape us." And I can't think of a better place to talk about sort of a restoration of classical values of separation of powers and rule of law than in this conference room. Now, on reforming, the tools available for reforming Obamacare, Rome wasn't unbuilt in a day. The administration has had years now to sort of set in place both legislation and rules and guidance and so on to entrench its system. And so reform outside of legislation it's not a day one thing. It's not a first 100 days thing. It's going to take time. Let me just go through these. First and foremost, the most important thing is notice and comment rulemaking. The administration has promulgated no shortage of rules from a variety of agencies. Through the process provided under administrative law, the agency proposes a rule. There's a certain number of days for the public to comment. The agency finalizes the rule. You can't just undo that wholesale with the stroke of a pen. You have to you're more or less required to go through the same steps in rolling back a rule. So there'll have to be proposals, public comment, and final rules. Now I said more or less because in some cases you could sort of accelerate the process through what's called an interim final rule or an emergency rule, something that you can put into place right away and then do notice and comment on the back end. You might do that for the most controversial or dangerous sections, the parts that are causing the most public pain. You might use this process to just change effective dates for various parts of rules, modify those without going through notice and comment rulemaking. In many cases, there's pending litigation. Right? That provides opportunities for the new administration to settle the lawsuits, concede legal error, conclude some sort of settlement agreement with the challengers, basically locking into place legal positions that can help drive the next administration in its rulemaking. In recent years, there's been increased attention to what's known as sue and settle, where basically friendly groups, this happens a lot in the EPA, a friendly environmental group will come and nominally sue the administration. They'll file a lawsuit, but the administration knows it's coming. The administration likes the lawsuit because they want to change policy, so they all agree right away as soon as the lawsuit is filed to settle the lawsuit and lock in a legal process for entrenching that position. In this case, the lawsuits weren't friendly when they were filed. They were genuine lawsuits, but now with the new administration in place, there'll be an opportunity to settle those lawsuits and lock in, if not substantive aims, at least procedures to arrive at the new substantive aims. Now, Josh referred to government by blog post. This is the idea that separate from notice and comment rulemaking, on many occasions the administration promulgated guidance in a variety of forms, sometimes even in blog posts, reinterpreting aspects of the Affordable Care Act. Those actually can be done away with the stroke of a pen or a delete key, or you delete a blog post or delete a tweet or however they were governing. All of that can be done without notice and comment. That's very clean and cut and dry. One other thing to consider is the idea of waiver or just outright non-enforcement. In some cases, the Affordable Care Act expressly provides for waiver of provisions. Section 1332, as I understand it, and maybe I'm misunderstanding it, is the state innovation waivers, where the administration could waive the requirements of certain requirements of the Affordable Care Act in states where states are trying to be more innovative on policy. So that's an affirmative grant of waiver power, but in other cases, the administration might just waive laws using its broad power to not enforce laws under the doctrine of Heckler v. Cheney. You don't want to go overboard on that. I think going overboard on that is a serious threat to the rule of law and checks and balances. And there's been lawsuits filed on that over immigration. But on marginal details, I think it's safe to say that it's well within the administration's power to waive or defer enforcement, at least in the short run. Now, I haven't mentioned in any of this executive orders. Right? That's the thing that the most attention will be paid to on day one. A flurry of executive orders President Trump will sign, directing agencies. Because like I said, so much of what needs to be done really isn't from the White House. It'll end in the agencies themselves. But to be clear, the president can use executive orders to shape that process. He can sign executive orders on day one announcing new administration policy. In the case of ambiguous statutes, and as we just described, there's so many of them in the Affordable Care Act, The president could press agencies to take a new look at things, to start new rulemaking processes, and he can even limit their discretion under D.C. Circuit precedent. When you're talking about an ambiguous statute, the president can use executive orders to effectively put blinders on an agency, to put them in the right policy direction and steer them away from other policies that are reasonable but not mandated by the statute. Just a final point, because I'm already out of time. In all of this, we have to keep in mind, as they'll be saying later, that the real goal is legislative reform, not executive branch reform. But on that point, I'm reminded of a quote from Alexander Hamilton, not in the Federalist Papers, but in his second suite of essays, the 1793 papers called the Pacificus Papers. And in one of these essays, he had a very important quote. He said, "The legislature is free to perform its own duties according to its own sense of them, though the executive, in the exercise of its constitutional powers, may establish an antecedent state of things which ought to weigh in the legislative debates." Today we'd call that a first mover advantage. The president has the power, in exercising his own constitutional powers, to shape the terrain on which the legislative debates will happen, to change the status quo, and I think in some ways that will be President Trump's most effective and important power.
But things do bog down and people get a little impatient and look for quick fixes. So we turn now to Daniel Merrin. I'm going to say that very loud and clear because I've been missing that on a few occasions. That's when you have two Dans on the same panel and don't pay attention. Daniel Merrin is currently global co-chair of Latham & Watkins Healthcare and Life Sciences Practice. He's also co-chair of the firm's Healthcare Services and Providers Industry Group. Even more particularly, Dan has deep experience at the Department of Health and Human Services. He served as general counsel from 2006 to 2007, where he supervised the work of approximately 500 lawyers. He knew all their names and pronounced them correctly out loud, unlike your moderator today. And was very involved in just the whole panoply of those healthcare issues. And he has other experiences, many people here do, clerking in this case for Anthony Kennedy on the Supreme Court and also at the Court of Appeals. We asked Dan to talk about, as a wise counselor, you represent industry clients, and you've represented, government officials, to say, calm down just a minute. Here's what we think you can do, but maybe there's some other yellow lights flashing or some red lights as to where those parameters begin to get a little more narrow or absolutely are prohibited. And there's some uncertainties and unknowns as well. So if you're in that position to let's say a new president, I can't think of anybody in particular, saying, I'm going to do this, I'm going to do that, we're going to kind of turn it all over and upside down. What can he do? What can he do? And maybe where's kind of that gray zone?
So I'm the guy where fun goes to die, right?
That's right.
The cautionary yellow flags. And before HHS, I was at DOJ, where I defended a lot of my role was to defend a lot of administrative actions. So I consider myself an APA nerd in some respects. One of the interesting things growing out of the last few years in Obamacare are some of the long-term implications that have taken place, both in terms of a precedent of a lot of executive actions that we've talked about that I think have stretched the envelope. There'll be a strong temptation in the incoming administration to, I think, likewise try to stretch the envelopes in the other directions, and also in terms of administrative law doctrines. I want to start with which have created some real interesting sort of precedents if they're going to be have serious organic effects beyond the current statute. King v. Burwell is actually an interesting example because I know, Joel, the question of whether it's an example of judicial restraint or judicial activism, I think in part depends if you're looking at the Fourth Circuit opinion or the Supreme Court opinion. And here's what I mean by that. So we have a statute that, at least on its face, literally said that premium tax credits are going to be available to people who have purchased policies on an exchange, quote, established by a state. The Fourth Circuit looked at that and said, for various reasons, we think, although the words literally seem to say that there's ambiguities created by other provisions and the unintended consequences if it was applied literally. And so the conclusion the Fourth Circuit reached was, as a result, we're going to say there's ambiguity under administrative law traditional concepts. We assume that ambiguity was left for the agency to resolve. Pretty standard stuff, and it basically said under the Chevron framework, we're going to defer to the administration's interpretation of it. It's very important. Had that been the rationale of the Supreme Court, then one of the very first things that the current administration, I think, would have considered doing would have been to simply take a different interpretive position. It might have had to go through notice of common rulemaking, but certainly it could have been open to take the position that no, in fact, the premiums are only available if you buy it on a state exchange, which would have had a very, very quick impact in terms of curtailing the healthcare statute. It goes up to the Supreme Court, and Justice Roberts has basically said, well, if there's an ambiguity in a statute, and the ambiguity goes to something that's really, really important and central to the statute, and God knows what that's going to mean in other contexts in the future, then we don't think it's been left to the administration to resolve that ambiguity, and instead the court's going to decide it. And so I actually don't think that King versus Burwell could be defended really as an example of judicial restraint, at least in the sort of common way that term is used. And the Supreme Court essentially resolved the ambiguity on its own and said, no, the better reading of a statute is that it means effectively it includes the federal exchanges. The impact of that is that although there's going to be a lot of temptation to try to reverse that, I think the administration's stuck with that interpretation now. I think it's going to be very hard for them to say that there's an ambiguity left for them to resolve after King versus Burwell. But the second place that they, I think, would be likely to go, and this is the other thing that the executive branch does, besides acting sort of an administrative hat, issuing regulations, et cetera, it also controls the litigation for through DOJ and litigation positions that the executive branch takes. The litigation currently on the availability of cost-sharing subsidies, whether they're appropriated, whether they could be continue to be made, is one that I think at first blush there's a lot of people out there sort of who voted for Trump and who want to end Obamacare were sort of rubbing their hands together and saying, okay, here's where we can almost immediately have an impact. I think my prediction is this is going to turn out to be a massive headache rather than an opportunity, and something that people are going to have to think about. And the reason is that if you believe, as many in the incoming administration do, and certainly the House of Representatives, at least the Republicans, said, that there is in fact no current appropriation authorizing appropriation for payment of the cost-sharing subsidies, then it's really not a question, if that is the current incoming DOJ's position, then it would actually become, I think Josh referred to the Anti-Deficiency Act, it would actually be a criminal violation of law, criminal violation for the executive branch to continue making payments. And I know that when we were in the administration, when there were very close questions, people take this seriously, or at least used to, and they did go to the Office of Legal Counsel and try to get opinions about whether a particular expenditure is or is not appropriated because of the personal criminal responsibilities of the authorizing official. This is going to be we've heard obviously a strong desire among the incoming administration to repeal and replace. We've also heard transitions. But they want some transition. This is one where there's going to be a tremendous bind right off the bat, because if in fact the law as currently written does not appropriate the money, this is not a question of, but we'll still spend it for 2 years under transition. I don't know how you get there. No. And that's one of the things people are going to struggle with, and you may end up with this irony of actually Republicans going to Congress to obtain an appropriation for the short term.
That is where it'll end up.
Well, that it's going to be fascinating, right? Because that's actually very different from HR 3762, which is the last reconciliation bill, but it'll be very interesting. I think that actually is probably where it does end up, but we're not supposed to assume any legislation for our
Not
panel
yet,
we're talking
not yet.
about. Not yet. So, but as a matter of administrative law, right now that would be a real headache for the administration. Absent the change of law, which is how we're looking at it today, I think what you're looking at is almost a prospect of a mandatory cessation of those payments, which will then trigger lots of very immediate consequences for the statute. Another thing that's been bandied about in the toolkit.
Well, we do know that Donald Trump likes stiffing people on their bills, though. That is that is unfortunate.
I'm not going to comment on that one. But one other thing that I think people are going to want to think about and consider is, obviously one of the major portions of the repeal legislation that passed last time was eliminating the individual mandate. The question is, I think, an interesting one, whether in light of precedents set by the current administration about the employer mandate, which was repeatedly waived and extended, Does the current administration actually take the position, or try to take the position, that it actually has the authority without legislation to effectively either not enforce or repeal or suspend or whatever you want to, not repeal, but suspend, not enforce the individual mandate? The employer mandate, individual mandate are both written the same way in the state. They're basically both taxes, at least certainly as the Supreme Court has interpreted them, but the languages are so similar. I don't know how you would conclude that one's a tax and one's a penalty. I think they'd both be sort of written the same way. It's somewhat unusual for administration to take the position that it has, as a matter of administrative law, the authority to essentially not collect taxes, which is very different from not enforcing penalties. The rationale given for suspension of the employer mandate has been that there's a need for transitional time. I think Josh raised fair questions about whether that's really rationale that you can still accept a number of years later. With respect to the individual mandate, I think it's even harder. It already went into effect. So I think it would be very tough for the administration to go about it that way. But in the event that the premium subsidies are in fact eliminated, I think it actually would not be very hard at all for them to construe the hardship exemptions to effectively do away with the mandate requirement, because once you start taking away the ability to get subsidization of your cost sharing, your premium, your co-pays, your deductibles, certainly for lots of people, I think it would be actually pretty uncontroversial. I think the outgoing administration would agree that that would be a hardship and it would create affordability issues. As to those, I think it would be not actually a very heavy lift at all for the administration to go about it administratively and to effectively more or less get rid of the mandate doing it that way. That's another irony there, is if the government does, if what ends up happening is because of the pressure, there is an appropriation, I think that's a different story, but that would be part of an effort to essentially extend.
How many exemptions do we currently have already for the individual mandate?
There are many, many.
15 or so.
Oh, there are more. There are individual exemptions on a case-by-case basis. There are a lot.
Agree.
And even aside from that, there's always the question of how many resources are actually going to be devoted to enforcing and collecting. This is just standard executive branch stuff. It's the allocation of resources. How much are you going to spend on that? How much are they going to spend on outreach and enrollment efforts? I suspect very little, even if there's a transition. So there's sort of soft ways of not killing, but imperiling the prospect. I think that as Adam said, a lot of this was done through notice and comment rulemaking. So there'll be immediate pressures, as there sometimes are after 8-year terms, to switch to try to see if there are ways to essentially suspend regulations and not enforce them. I think. I think under the D.C. Circuit law, I think it's once you've got something that's really a final rule, if you're blanket suspending it and announcing that's I personally think requires notice and comment rulemaking again. But then there's the softer forms of turning blind eyes, not really going afterwards, and everybody knows it's not really being enforced. That's very hard to sue on. I don't know how anybody even tees up a case like that. So just trying to keep it short.
Yeah,
so
that's a great start. Let's
that.
Toss it to Daniel Hemmel, who's assistant professor of law at the University of Chicago Law School, and one of the courses he teaches is on administrative law, and he's also had plenty of experience clerking at the highest level of the courts, including the D.C. Circuit. Daniel, no problem whatsoever. Everything worked like clockwork. I'm taking it to the extreme in terms of what's already in place, or could it be reversed? Maybe not overnight, but rapidly. What are the constraints within the legal system that prevent the before and after transformation, or what are at least some cautionary factors in how you would or wouldn't go about it?
Well, so Dan said that his talk was going to be where fun comes to die. That's actually the University of Chicago's motto. So we'll get nitty gritty here. There was a pop culture theme to the intro that the live audience saw. But that the folks who are streaming this did not. I'll continue that pop culture theme. I guess really Adam continued that pop culture theme by quoting pop culture icon Alexander Hamilton. I would like to channel Miracle Max from The Princess Bride. There's a big difference between mostly dead and all dead. Mostly dead is slightly alive. I'd say the ACA is better than mostly dead, better than slightly alive. It's not dead yet. and it's not going to be so easy for President Trump to kill the ACA or even seriously wound it on day one. So here I'll focus on 5 things that he might do. He might drop the Obama administration's appeal to the D.C. Circuit in House versus Burwell, which my co-panelists have talked about. He might halt reinsurance payments to insurers. He might block any settlement of the risk corridor lawsuits. He might grant waivers to states under Section 1332, as Adam suggested, and he might change the definition of essential health benefits through notice and comment regulatory action. I guess Josh also mentioned he might kick members of Congress off their health plans. That would amount to a massive compensation cut for congressional staffers, so then not only would independent wealth be a prerequisite for appointment to the cabinet, it would also be a prerequisite for a congressional staff position. But that's really neither here nor there. Now, 1, 2, and 3 are all within the president's power. Dropping the suit in House versus Burwell, halting reinsurance payments to insurers, and blocking any settlement of the risk corridor lawsuits. But I don't think they'll accomplish that much. I think the Section 1332 waivers would run aground on the shoals of judicial review. And changes to the definition of essential health benefits might be possible legally, but I think would be disastrous politically. So let's start with House versus Burwell. On day one, President Trump can and maybe will tell the Justice Department to drop the appeal to the D.C. Circuit in House versus Burwell. The issue there is whether the Department of Health and Human Services can compensate insurers for making the cost-sharing reductions necessary to comply with Section 1402 of the ACA, given that Congress has refused to appropriate funds for such payments. And under 1402, silver-level health plans offered on ACA exchanges must reduce copays and deductibles such that plans cover 70% of costs, scaling up to 94% of costs for individuals whose income is between 1 and 1.5 times the poverty line. And Section 1402 requires HHS to make periodic and timely payments to insurers in order to compensate them for these cost-sharing reductions. But the statute doesn't appropriate funds, and Congress hasn't appropriated funds. And in May, a D.C. Federal District Court judge ruled that HHS can't make payments to insurers pursuant to Section 1402 unless and until Congress appropriates funds, which it won't. And if Trump drops the appeal, then presumably the district court's ruling stands and the payments from HHS to the insurers stop. And then what? Section 1402 still applies with full force, so insurers selling silver plans on exchanges still have to make the cost-sharing reductions that the statute requires. Presumably they'll respond by raising premiums, but low-income individuals enrolling in silver plans generally won't pay out of pocket because Section 36B of the Internal Revenue Code provides a tax credit for individuals under 4 times the poverty line who purchase insurance on exchanges. And that tax credit is keyed to the price of the second lowest cost silver plan on the exchanges available to that individual. So the credit ensures that individuals making 4 times the poverty line pay no more than 9.5% of their household income for the second lowest cost silver plan, scaling down to 2% of household income for individuals who are at the poverty line. So if Trump drops the appeal, silver plan premiums go up, credits rise commensurately. The biggest winners, individuals whose credits grow and who use those credits to purchase not silver plans but gold plans, the premiums from which probably won't go up because the gold plans aren't subject to Section 1402. And the biggest loser is the U.S. Treasury. The reduction in payments to insurers is offset by the increase in credits for individuals, and now Treasury is paying more than it was before to individuals enrolling in gold plans. So the ACA survives intact, except now the subsidy for purchasing a gold plan is even more generous. Okay, transitional reinsurance. On day one, President Trump can order HHS to prioritize payments to Treasury over payments to insurers under the transitional reinsurance program established under Section 1341. That provision effectively requires HHS to transfer funds from insurers who cover low-risk individuals to insurers who cover high-risk individuals. The statute instructs HHS to collect money and deposit some of it with the Treasury Department. Here's the problem. HHS's contribution formula led to a shortfall of funding for reinsurance. And so HHS had to choose how to allocate scarce funds between the insurers and the Treasury. It chose to prioritize payments to the insurers. Republicans in Congress objected. The Government Accountability Office concluded that the Republicans are right and that HHS must make the required contributions to Treasury before it disperses funds to insurers covering high-risk individuals. President Trump can tell HHS to stop making those payments. Now, HHS has indicated that at least $7.9 billion has gone out to insurers already for the 2014 benefit year, and possibly more by now for the 2015 benefit year. So even if Trump halts further payments, it's not clear how that weakens the ACA. Right? Insurers would experience a negative wealth shock, but why should that affect what plans they offer going forward? They'll continue to operate in markets where their plans are profitable. The loss of these payments is a sunk cost. Moreover, the transitional reinsurance program is just that, transitional. It covers 2014, 2015, and 2016. So there's no obvious reason why it will affect the sorts of plans offered in 2017 and beyond. The risk corridor lawsuits. Okay, the risk corridor controversy is the polar opposite of the transitional reinsurance dispute. The claim here is that HHS hasn't paid insurers what it should have, whereas the GAO's conclusion was that with respect to the transitional reinsurance program, HHS did pay insurers what it shouldn't have. Section 1342 requires HHS to establish and administer a program of risk corridors for 2014, 2015, and 2016, and limit the losses for insurers offering plans on the individual and small group markets those years. Significantly, the statute is phrased in mandatory terms. HHS shall pay. If obligations to unprofitable plans exceed collections from profitable plans, the government must fill the gap. The problem is congressional Republicans attached riders to spending bills in 2014 and 2015, stating that HHS cannot use money from anywhere else to pay risk corridor expenses. The result is that the statute says HHS shall pay insurers when Congress says HHS shall not. So insurers sued. Justice Department officials have reportedly talked to insurers about settling. President Trump conceivably could tell the Justice Department not to settle and instead to fight the insurers in court. But to what end? The insurers have a very strong statutory argument here, and they'll likely prevail. The Trump administration might refuse then, even then, to pay up, though that strikes me as playing with fire. It would effectively amount to the U.S. government defaulting on a court-determined debt. What would that do to the full faith and credit of the United States? What effect would it have on benefits in 2017 and beyond, given that the risk corridor program ends this year? And again, it amounts to a negative wealth shock for insurers with no obvious implications for plan offerings going forward. Okay, the fourth thing, Section 1332 waivers. 1332 allows HHS and Treasury to waive large parts of the ACA, including the individual and employer mandates, in states that submit plans satisfying certain statutory criteria. HHS and Treasury may grant a waiver request only if the Office of the Actuary of the Centers for Medicare and Medicaid Services certifies that the state plan will provide coverage at least as comprehensive as the ACA Essential Health Benefits Package, and if such coverage is at least as affordable and reaches at least a comparable number of people as would be covered under the ACA, all without increasing the federal deficit. Waivers may be granted starting January 1st, 2017, and may last as long as 5 years. Does this provide an exit strategy? Well, first, the chief actuary of CMS, whose certification is necessary, is not himself a presidential appointee, and he's removable only for cause. Second, the 1332 waiver would be final agency action and would be reviewable under the APA. If states can devise alternatives to the ACA that satisfy these statutory criteria, then yes, Section 1332 provides a route out. But it's not at all clear how they could do this without reimposing the individual and employer mandates at the state level. Finally, essential health benefits. So Section 1302 of the ACA instructs HHS to issue regulations defining the set of essential health benefits that non-grandfathered individual and small group plans must provide, but regulatory discretion is not unbounded. If HHS wants to change that definition, it needs a certification from the same CMS chief actuary that the scope of such benefits is equal to the scope of benefits provided under a typical employer plan. Now, this requirement still might leave the Trump administration some wiggle room to make the essential health benefits package slightly less generous, but each regulatory change will be subject to judicial review under the APA, and even if these regulatory changes hold up in court, they may fare worse in the court of public opinion. Imagine the political fallout when the Trump administration tells diabetes patients that insurance will no longer cover their insulin pumps, or tells parents that their children's glasses frames aren't covered anymore, all because this will push premiums market-wide down. This is exactly the box of the Wilson-Hayes matrix that you don't want to be in. Concentrated costs, diffuse benefits. So even if Trump's legal advisors tell him that he can do this, and he might be able to, his political advisors might not be so enthusiastic. This list is non-exhaustive. The bottom line,
Yes, it
though,
is now.
is that if Trump wants to dismantle the ACA, then he'll need to repeal and replace rather than drop lawsuits and deregulate.
Thank you, Daniel. That was a extensive, we were going to file for cloture there in just a minute, as we've jumped the rails over from the law to the little bit of the blend in the policy. We'll get kind of some responses from the panel. I don't want to go through each individual piece, but kind of if you could hit some of the high points. Adam, you wanted to, I think, chime in on something?
Yeah, just one. I think this is an important point because as you've seen now over and over again, there's going to be a lot of lawsuits. There's going to be a lot of agency actions that trigger lawsuits that trigger judicial review. And I think that illustrates why it's so important for the new administration, if it wants to succeed in its reforms administratively, is going to have to resist the urge to do things quickly and do things prudently. I mean, really, in terms of the judges deferring expressly or implicitly to what the agencies do, they'll be more likely to defer to the new administration's changes in policy if these things are seen as thoughtful and thorough. There was a law review article about 10 years ago called Chevron Deference, Judicial Deference from Politics to Expertise. This idea that the court cases were showing that courts were deferring more to expertise than to political judgment, even though both are really bound up in the doctrines of judicial deference. I think that's important. My main advice to the administration would be, in all of these things, measure twice before you cut once, because once you change these policies and they go into court, you'll be practically goading judges, especially liberal judges, into gumming up the works. If what you're seeing, if you're seen as doing all this glibly rather than thoughtfully and thoroughly.
So saying we won, we get to change the law may not really work as reasoned analysis for overturning a reg?
No, and I'll say the New York Times and other press excoriated the D.C. Circuit and other courts for the last 8 years, screaming about judicial activism and getting in the way of agencies. I think that's one of the things that will flip in this Jane Austen reversal, and now you'll see the New York Times, just as it did throughout the Bush administration, praising courts for taking time to intervene in the reckless policies of the new administration. I mean, it's not cynical, it's just realistic what's going to happen.
So shock and awe in the first weeks of the war may turn out to be shock and awful if it happens quickly with a moving beyond Twitter to actually changing regs and
Don't declare
guidance.
mission accomplished.
Well, let's hear from Dan Marin on this. There's a lot on the table. We can argue on the policy to some extent. We can also argue a lot on the law, because there's probably more than one point of view on that. But what does this suggest in terms of threading that needle? I mean, things do bog down in Congress. It doesn't exactly work out ideally, and there's always a temptation for an executive override to some degree or greater degree to clean things up or to get there sooner. Maybe it's too much of a high-risk strategy to force the issue ahead of time. But there may come a moment where that happens, saying, take one more non-step and I'll blow things up. In that type of world, what's a navigational path from what we've already heard discussed about what you can and can't do under the law? And we're moving now toward what you should do, or what are the repercussions, and if you're going to do it, you're going to have to do it more carefully.
Well, I mean, I think the hardest question is, and it goes also to the timing, is as they try to balance what they can do and what they ought to do, we've already heard that the incoming administration say that there's certain aspects of the current law that they want to keep. They've also said they want to keep as many, or I mean, a little fuzzy on this, right? But there's a lot of people who do get insurance currently on the exchanges or through the Medicaid expansion. We've mostly been talking about the exchange part of this today, rather than the sort of Medicaid expansion. There's going to be a strong fear of getting blamed for people who suddenly overnight no longer have coverage, and for that reason, I actually think that. Adam, your cautionary note is actually what's going to. I think this is going to play out. My prediction is much more in the short term on the Hill than it's going to go through administrative action. What I do think there is a chance, other than immediate issues that have to be taken. I think the House versus Burwell case, they're not going to be able to duck that. They're going to have to make a decision pretty early on as to what the position is, I think it will actually have a very strong dislocating. You're talking about raising premiums for people in the next year who've already signed up. I don't know that you can in the midst of a year raise your premium. It's outside.
You can't.
You cannot.
No, the regs are quite clear on that.
Right. So what I'm told, and maybe you'd know better, I'm told that the current carriers, when they bid this year, essentially put in provisions that said that if this provision goes away, they get to exit. So I
But
actually,
they've still got other
that's
law
also
that doesn't
very
let them
vague.
exit.
I'm sorry.
HIPAA, it stops them from getting 3 months at a minimum. State laws can override that as well.
Yeah.
But you're
The
right,
regs-
you're right.
The regs don't allow that mid-year thing necessarily. There's a clause that could be used.
Yeah, I mean, I think it's going to be an interesting question. I think there's going to be serious also litigation and contract questions about whether you
Right.
could do that. I think it's actually going to be much more disruptive and chaotic than simply they're going to raise premiums, no problem, and then we're just going to get the same. We'll get the same effect because essentially the premium tax credits will replace the cost subsidy credits, if I'm getting those words exactly right. So I think that there will be obvious dislocations. What you might end up seeing is actually a dance in the opposite order, and I think you hinted about this, Tom, which is if the repeal and especially the replace parts do get bogged down, and replace very easily could get bogged down, do you see the administration then trying to do things actually in a calculated way to create time bombs and to require congressional fixes? But will they want the political ownership of that? And that's going to be
Right.
one of the hardest things. But at that point, if you're no longer constrained by this notion that people who are currently insured will not lose it, if that's not a policy constraint anymore, there's a whole host of things you could do effectively over time, certainly, to effectively kill it. But then,
Just from practical experience, though, I mean, we always talk about, you can say one thing and then you've got transitional issues, you've got everything being interconnected, how that ripples through. That's just a natural slowdown in whatever you stake out as your pure position, then you actually have to implement it and make it come about.
absolutely.
All right, by the way, Joel and Josh are now officially out of the penalty box since we've gone into pundit land. So, Josh, you had probably a few targets of opportunity on the table. I can cue you up if you want to, or you can
Give me a
decide to-
question. Give me a question. I'll take it.
Well, we've heard about payments which are illegal. We're going to have to continue because that's the only thing you can really do, and we'll just work out it expediently. We might call them something else, which is another workaround possibility. And that waivers have always been exactly according to the rules and carefully certified. Although I seem to remember an Arkansas waiver, which for Medicaid worked a little differently. So that's just. I'm wondering whether there's a little flex in the a great presentation by Daniel, but whether there might be another point of view on some of those points he raised.
Very early on, the Trump administration will have to make a series of judgments, I think as my colleagues have noted, with respect to these cases. Do they want to drop the appeal? Do they want to try and actually sue and settle, like Adam said, maybe use the House v. Burwell case as a way to maybe take some settlement to temporarily make the payments? Or do they want to say, screw it, let's stiff them and let them sue us, we'll figure out later? I don't need to remind you that Donald Trump is very good at stiffing contractors. He's done this in every facet of his life the past few decades.
And now he has a whole Justice Department to work
Defend
as his
him. I mean,
counsel,
free
defend him.
legal counsel. So in the event that these payments stop, I think Dan H. Is correct. And if you read his blog post, his speeches are in his blog, go read it. It's a good read. The insurance companies will come and sue. And then you have to deal with the judgment fund. Then you have to deal with defending it. Then there's various defenses of standing. Justiciability. Are these suits ripe? Are they ready? I would object if they start making these payments, 'cause I think they're illegal. With respect to the cost sharing, the Treasury deposits, Dan mentioned one thing I have to object to. The shortfall in these payments is not because of a formula, it's because it hasn't generated enough money. Obamacare simply hasn't made insurance companies profitable enough. So what they did was they basically raided the Treasury and they put money to give insurance companies first. I would not only be aware of that, I would about clawbacks. I would actually want to sue the insurance companies under the Anti-Deficiency Act for taking money that was illegal. I would prosecute these people as well, but thankfully I'm not in charge. But again, they're going to have to make very quick decisions about how strict they want to be with enforcing the rule of law, and I will probably be complaining about what they do.
So just on the judgment fund, because when I was in the civil division, agencies just love the judgment fund. They think this is their way. They're going to solve all their budgetary problems. They're going to have these sue and settle cases, and then they're going to go to DOJ and say authorize payment out of the judgment fund. And at least historically, the department has been has been viewed as one of its obligations as essentially being a defender of the judgment fund. Historically, if you cannot use the judgment fund to cure a problem where Congress has mandated a particular programmatic or other activity for the agency but failed to appropriate funds. And it gets very arcane and technical, but I actually think that after initial hints by HHS that it would settle these cases, I think what you're starting to see is that they're hitting up against, I have no inside information, I'm predicting OLC telling them, no, I don't think you can actually use the judgment fund, and I'd be very surprised if the incoming administration would say,
Well, we've
that the
had
judgment fund's
dueling
available.
briefs, so to speak, or positions even by this administration
Right.
from where HHS was and where the just lawyers were in some of those insurer cases.
And I think what's happening is that essentially OLC is now there's nothing public, but I think what's happening is OLC is saying, wait a second, that's not the executive branch position historically, and we don't see how we can get there without creating massive problems for us going forward.
One of the things that differs in this fuzzy area as to how you look at the law and what you do with it is people. I mean, you put different people into these positions, they start to interpret things differently. Now, maybe the actuary will be a little bit different unless they get a late night nudge, which has been known to be suggested by people before. But normally that's one ground. So how much just a transition of, and Joel, you speak to this, the people in place are going to look through this through somewhat different eyes. And Dan was talking about enforcement has a lot of latitude in either direction, is what you emphasize or don't. So how much is just a change in folks who are motivated differently make the executive branch respond in a different manner in what's supposed to be settled law but has a lot of slack in it?
Well, I have to say, generally, I'm sort of surprised at the tenor of the discussion in this respect. It's abundantly clear, and you can read any liberal blog today to find this out, that if Congress wants to get rid of this law immediately, they can. There's no problem. And if Donald Trump wants to get rid of it immediately, he can. He can disrupt people's coverage in 2017, and the law will be toast. So this all can be done. I think Congress is much more likely to do it than Trump. I mean, if you look at what they've said, the leadership of Congress has said repeatedly, they've done it 50 times, repealed the law. They've repealed the mandates. They can clearly do that day one. They've repealed the tax subsidies. Guess what? If they want to do that and make it effective immediately, the law is toast. It's gone. So Congress can do it. And Adam, to your point about the legislative branch should be in charge, I'm surprised that you guys aren't all saying, why don't we just get the administration to step back and let Congress do the work that it should do if it wants to do that? That's how our society should work. By the same token, if they don't want to do that, if Congress doesn't want to be accountable, and guess what? I don't believe they do. I don't think they do want to disrupt all this coverage. I don't think in the end they're going to actually get rid of the law, because they're actually going to say 8 million people who have coverage. We saw what Obama looked like. He looked like a deer in the headlights when 1 billion people were potentially going to get better coverage, just have to pay a little bit more money for it. And he said, well, we got to, do all these transitional relief things. I think even Donald Trump, I don't know quite how to think of Trump as a deer in the headlights, but when 8 million people face him and he says, Congress wants to disrupt your coverage, take it away, I don't think he's going to say yes to that either. And I don't think but Congress is going to own that. So I don't think these things are going to happen, but as a matter of law, very easy for them to happen. And if they won't do it, and Trump has the nerve to do it, if he wants to do it, he can do it. He can cut off the CSRs. There are no, under the regulations, no mid-year rate increases. They don't necessarily have to let the insurers out, but some of them will go insolvent. So they'll be out anyway. I know that from an insurance perspective. So if they want to disrupt this, all they have to do, I think, by the way, Mr. Trump might have a different attitude on the lawsuit, which will be, actually, I don't like Congress having standing to challenge my executive actions in this kind of way. That's a gross example of judicial overreach. Right now, that Roberts is going to be in the middle between Congress and the executive on things that Congress has its complete ability to change if they want to. They can cut off CSRs. They don't need to go to court to get CSRs cut off. So you might actually see that in that case a different outcome of the case going on. But if it doesn't, this will be the first test, because the Congress will have to vote in some form or fashion to keep the CSRs flowing even in 2017. If they don't do it, I think these guys are right. The executive agency is not going to do it because it's a criminal violation to keep doing it after the case is gone if that district court decision stays. So unless they take affirmative action to prop up Obamacare, we will have a disruption in the middle of this year for 6 million people or so. Not everybody's on subsidies. So, this could come to a head right away, but guess what? If they don't do that, that will be very public too, and the Freedom Caucus will erupt. And also, I thought we were getting rid of this law. Now you guys want us to actually prop it up for another year or 2 years or 3 years. But if they do it once, I will submit to you that the whole dialogue changes into, actually, these guys weren't really serious about fully repealing the law. They only want to cut back on it a little bit, and now we're in a settlement kind of mode, and that's where we should be, in my view. I think we'll get there, and I think all your points are well taken. None of those issues are actually going to be able to undo the law. They could if they wanted to, but I don't think they'll do it.
Well, we still got a few eruptions ahead, I think. All the volcanoes have not gone off yet. Yes, go ahead, Dan.
Just to respond, so on the CSRs, it's an interesting point because I think people overlook the fact that despite the tremendous upheavals and the emotions with elections, there's a long-term executive branch momentum and interest that tend to not change dramatically. From people overlook it. We always look at the part that changes. The part that doesn't change, and I actually completely agree with you, I think there will be once people think about it, I think the long-term institutional position of the executive branch would be against the standing of the House of Representatives in that case. So that could result in two things. It could mean to continue an appeal on that. But they could do something else, which is since they agree on the merits, they potentially could try to settle it and then move to have the district court opinion vacated under something known as the Munsingware Doctrine, and basically try to get rid of the precedent that way.
Can I say, we all agree to this, right? There's no president since Hoover who's voluntarily gone and said, now that I'm president, I want to give the power back to Congress. They've all changed their mind.
Carter, Ford, Nixon.
They wanted to give power back to
Oh,
Congress?
sure. As we're Cheney and the whole generation of unitary executives, the conservative side arose from the ashes of the presidency handing power back to Congress in the 1970s.
So Dick Cheney stands for the proposition that he wants to diminish executive power.
Dick Cheney was the response to that.
Oh, okay.
But Joe, I think the harder issue is not on the litigation per se, because I agree with you. They might take the position that they want to continue litigating standing. Leave aside the litigation. Let's say it never even happened. The executive branch currently has to make a determination on its own. Does it believe that the subsidies were in fact appropriated? If it doesn't, the position of the House Republicans obviously is no, it wasn't. If the incoming administration agrees with that, they're in a tremendous bind because they're legally prohibited from spending that money on pain of criminal penalties. And leave aside litigation. I think that's where they're going to have an almost immediate.
I agree. They're going to have to own this in some form or fashion.
Right. Not necessarily. If I got my religious quotes right, St. Augustine would say, give me accountability, but not right away. There's always ways to stretch this out a little bit further before you own it completely. One of the factors in this is also, about 4 years ago, I remember a bunch of folks worked on what an incoming Romney administration could do to turn around the law and change all these things and what kind of spheres of authority we'd have. A little less buoyant about being able to do a slam dunk through the legislative process. That was before this law was implemented in place, and some things were not just about to come and might be delayed, as we saw many of them happen, but they're now in place. Does that even more so constrain what you can do to remove that you might have if you were simply in the position of, well, we're going to implement this differently, or we're going to do it later, or we're going to do it in a different manner? That's a rhetorical question.
Absolutely. Yes. I mean, I'll be very quick on this. Absolutely. I debated Ted Cruz on a show right before the law went into effect in 2013. He said, this is our last chance to change this law. Once it goes into effect and millions of people are covered, we'll never change it. I said, that's the only thing I agree with you on here tonight. If you don't do it now, you won't be able to change it later. We'll come back in a year. There won't have been a lot of change in the law because of the reality of 10 million more people. We're talking those 10, and as you mentioned, there's another 10 or 20 million on Medicaid. So there's a lot of safety net that's been built that in our political system, for good or bad, doesn't tend to get unraveled.
Unraveled, use the book title. Thank you.
Getting an extra credit along the way. Well, one of the hypothetical concerns, and now this panel says it, since they're not going to do it, we don't have to worry about it, is the possibility, and Josh, you might speak to this, whether we still could enter a recurrent, repetitive cycle of, I think the phrase was, well, he did it first during one of the debates, and then having to, in effect, return and retaliate. And the question is, who blows the whistle and says, we're all even, or you get to kind of start behind, but we can't do any more of this?
Every administration, I think with the exception perhaps of Carter and Ford and others, tries to build on what the previous administration does. And I think there's almost a sense of a reckoning or awareness now where all of the people who supported President Obama's executive actions are saying, oh crap, what did we do? We've just given the keys now to a madman, right? We've set these various precedents for waiving, suspending, and modifying statutes by blog posts. And now this guy we think is really bad will have that same power. Oh crap. President Obama gave a speech recently where he said, people are, have given up on democracy, that, people think, oh, government takes too long. This is the same president who had how a bill becomes a law, right? Kicking the bill down up to Capitol Hill. When you set precedents, it's dangerous. I was on the PBS NewsHour the day that DAPA was announced. This is the president's executive action immigration. And Gwen Ifill, when she rests in peace, was asking me some questions. And she's like, Josh, why are you so opposed to this? Aren't we going to be helping these young, wonderful immigrants and their families? Isn't this a great idea? And I said, Gwen, what happens if, President Ted Cruz decides to suspend environmental regulations, and President Rick Perry, it's early, decides to suspend this, and President Rand Paul decides to suspend the corporate income tax? And I could hear her voice saying, oh, wait a minute. This extends beyond Obama, right? And for all, it was going to be Clinton, right? It's going to be Clinton, no big deal. Yeah, it's not Clinton. It's Trump. Deal with it.
Now, we're in one world where some folks believe that the entire slate is wiped clean, not knowing what comes the day after in terms of a full-out repeal. But there are other intermediate steps which could change parts of the law, both legislatively and administratively. But maybe there's a bit of a straddle. And I talked to Daniel about this a little while ago. We hear sometimes great claims for what could be done through the Congressional Review Act for existing regulations and how Congress could overturn them. That hasn't happened very much in practice. Is that just because of lack of opportunities and coordination between the executive branch and the Congress? Or how far could that reach in terms of what type of regulations could be subject to this and how that process might or might not come about?
So the Congressional Review Act hasn't been used more than once in the past because the only circumstances under which it would be used are when the president who promulgated the regulation is different from the president in office, right? It really is designed for transitions. Congressional Review Act joint resolutions are subject to the veto. So unless you have someone new in the Oval Office, then you're not going to be able to undo executive action through legislation. What the Congressional Review Act does do is it allows a filibuster-proof path to getting rid of any reg promulgated within 60 legislative days of the end of the last session. So legislative days are counted strangely, so this effectively takes us back to the end of May 2016. It doesn't take us back to the dates of some of the crucial ACA regs. So it doesn't take us back to the big essential health benefits regulation. And while it's filibuster-proof, there's still an opportunity for 10 hours of debate on each joint resolution. So that means that we're going to be taking up a lot of time in the first 100 days of the Trump administration if Republicans in Congress really want to undo each reg that the Obama administration has promulgated since May. I think they will be able to take down the most significant Obama administration regs since May. I think they probably will be able to take down the Section 385 debt equity tax regs, maybe the big ERISA fiduciary responsibility regs, but we're not going to see a complete undoing of the Obama administration's last year of executive action, and the Congressional Review Act really doesn't do anything for Congress with respect to pre-May 2016 stuff.
So we're moving toward the closing part of the predictions of would and the predictions of should. Before I get the blanket one, let's just kind of go back to an area which Adam touched on initially, but we didn't really flesh out. It depends what your shopping list is. Executive orders seem to involve a lot of potential creativity. There's still some blank space between the technical law. If you were looking at a Trump administration in the healthcare space, there's plenty of other areas to look at as well, not just blowing up old executive orders, but perhaps transforming them, does that provide enough working room to deliver some earlier victories while what might be a longer legislative process takes a while and might reshape some of the parameters? Just a guess. No, I'm waiting for hands. No single person involved.
No, I'll defer to you guys on this. I would just say that their power, without getting into specifics while my fellow panelists come up with their answers, is that the executive order, like I said, can place blinders on ambiguous laws, but also can help force items to the top of an agency's agenda, which is very important.
One really interesting one to watch will be CMMI, the Innovation Center. I mean, it's on the repeal list in all of the Republican legislative bills. But as you get closer to it, the question arises, gee, that gives some pretty flexible authority to do things that may not be as easy to do through Congress. And so maybe a Trump administration and a Price as secretary, assuming he's confirmed, like it. So it'll be interesting to watch whether CMMI is repurposed or whether it's eliminated.
Walking around money for a new set of lab experiments. We understand how that feels.
I would say some of the focus on executive orders is misplaced. A huge aspect of presidential control over agency action happens through memos, through directives, and through interaction, some of which is public, some of which is not, between the Office of Information and Regulatory Affairs and the agencies. If the president wants an agency to promulgate a specific reg, there are much better ways to do that than an executive order.
But Trump would love to do it himself. I mean, you're talking about
You get your
administrations that would
imprint
like
in
to
your
do
brand.
things underground.
Well, right, except there's
He
the
gets to sign
problem.
it.
There's the problem that unless he's acting under inherent Article 2 power, then most of these statutes delegate authority not to the president but to the secretary, right? So he actually needs to tell the secretary to promulgate the reg.
Can you
He
just
can't
tweet?
do that.
Can you just tweet tweet the agency? Hey, go do this. Would that be sufficient?
Well, I mean, some have suggested that Trump's tweets should be subject to sort of 60-day pre-publication
Note and comment?
review.
Well, on this point, though, and I don't want to go too far down the administrative law rabbit hole, because that truly is where the fun goes to die. But I think a great example of this is the outset of the Obama administration on the funding of embryonic stem cell research. This was a point where the Bush administration had a policy and a program administered by HHS, the National Institutes for Health. And Obama came in with, I can't remember if it was a formal executive order or a statement of presidential policy, but either way, he dictated what the new policy was going to be. And even though we're talking about a program that by statute is administered by the agencies, the DC Circuit in a case called Shirley versus Sebelius said that the agencies were bound by the president's directive on how to shape their policy. As long as they weren't contradicting an unambiguous statutory command, the president was able to lock the agency in a specific trajectory, so much so that the agency was excused from ignoring comments criticizing that policy in the notice and comment rulemaking. I think it's a very powerful tool in the president's, it's a powerful bullet in the president's gun if he wants to fire it.
Just to go at this a different way, let's say that Congress gets to pass the repeal stage and has had a lot of trouble with working out all the difficult terms of replace. We saw a lot of transitional improvisation by the Obama administration. First your grandfather, then your grandmother, then you suggest this might be a good idea, and then it turns out you've got money to spend that it didn't look like you had before. Would that provide a different temptation or opportunity for a Trump administration to fill in those gaps in what doesn't really get from here to there after having first impaired the law, needing ways to prop it up without necessarily a full-fledged statutory endorsement? Is there space there?
I believe absolutely that's what happens in one of the pretty tough scenarios, which is that they really do want to fundamentally alter the law and they do make fundamental alterations, but they don't want them to have any consequences for people today, which is sort of like how Ryan proposes to do Medicare reform and so forth. There is every opportunity then to have all the people who are currently in coverage, protected, transitional relief, grandfathering. And the dirty little secret about insurance is that, most people don't keep the same insurance for long periods of time. They change employers, whatever. So, you could have that exact sort of scenario of no one actually loses what they currently have, but no new people get through the door into the current system.
And perhaps some special incentives can be given to insurers who continue to play ball.
Well, and then you say, like Paul Ryan, well, even the new people can come through the door for the next 10 years. We'll only make these changes effective like so far into the future that no one will really care.
All right, I'm going to take one final.
The question is what that does to the pool. I mean, I'd be curious because this is your background, right? But the reason this became
It's
political.
a bad scenario. It messes up pooling very badly.
Right, and that's the problem. Is there's already been the theory that they had to do all these other fixes, like loosen up the enrollment period, or tighten up rather the enrollment periods, do other things, increase the mandate, all these things to bring people in, because right now you're spiraling into higher premiums. The fiscal consequences, even if it's not to the individual because they're subsidized, are very bad. And it turns out people reacted very badly to the headline of my premium goes up, and apparently didn't understand the messaging about the subsidies nearly as well, because you saw people who actually qualified for subsidies basically not going on in many cases. That just gets worse and worse if they have this transition. If they grandfather an existing pool, you're just grandfathering a pool that's really hard to sustain.
If there's one thing that Tom Pricey's got all kinds of good attributes, I have several really positive stories about him and interactions and so forth. One thing he doesn't understand is insurance pooling. And so if he's in charge, the Republicans are going to mess up the pools, and we're going to have all kinds of horrible adverse selection in the marketplace. So this would just be one manifestation of that.
Well, we'll see how deep the water is in that pool. Sometimes it's been overstated. I'm going to give a little fair notice to all the panel. We'll do one final roll call. Adam can be exempt from this if he wants to be, because he originally was going to excuse him, which was to get back to kind of the initial large question, and you go in whichever direction you want to. Your best guess, and I believe it's a guess rather than a certainty, as to what the Trump administration will do in this administrative law space, looking ahead over the next couple of years, not just the next week or two. And then on reflection, some people always say what they should do is exactly what they're going to do, because I predict the same thing regardless of what the question is. Whether there's maybe some different views as to, even if they overshoot the runway, what they should do and what they should be thinking about in that regard. And I'm going to start with Josh on that cold call, and then we're going to take some questions from the audience.
Well, I thank Tom and everyone on this panel. This has been actually a lot of fun. I think what we'll see is that because of the re-election, the Republicans feel compelled to do this repeal and delay strategy. This is using the reconciliation process. Only need 50 votes in the Senate to repeal chunks of Obamacare, not the entire thing, but significant portions. This will basically create this sort of game of chicken, if you will. Think of, like, in Greece, the cars are driving each other, who swerves first. At some point, someone will have to swerve, and it will be Grease Lightning indeed. Perhaps the Democrats will, or at least a couple of them who were up for election in 2018, will come on board and say, okay, my people are getting hurt by this, let me go along with Republicans. Maybe they won't. If you look at the electoral map, it's entirely conceivable that the Republicans have 60 votes in 2018. It's entirely conceivable, at which point it's screw it. We can do whatever we want, which may make the incentive to try and do something now before 2018. But the relentless assault of Obamacare, go read my first two books, has kept this issue alive. And people like Tom Miller and AEI and Michael Cann and others, this perpetual discussion of the ACA has enabled it to get to the point of 2016 that we're still talking about repealing the law that Ted Cruz thought could never be repealed. I didn't think in my wildest dreams that could happen, but at least it's given me some books to write. Thank you all very much.
That's the important ingredient.
I don't make royalties much, but go read Unraveled. Thank you.
Joel, surrender now, surrender later, or something in between?
Two predictions about where this heads. One is that, much to my chagrin, the sort of Republican support for the mandate and the notion of personal responsibility and not freeloading, exactly how Mitt Romney talked about it only a decade ago, is going to fail. I mean, it's just elections. The mandate's going to be gone. That will require them to figure out some way of creating some level of responsibility in the marketplace in order to have balanced risk pools. I think they're going to end up with this notion of continuous coverage. If you stay in the market, you get the benefits that you have under Obamacare currently of no health underwriting, no raising your premium because you get sick and so forth. So some form of continuous coverage with a high risk pool type of thing, which maybe becomes virtual high risk pools and reinsurance. That's kind of, I think, the core solution that we'll get to somehow through administrative and congressional action. I would like to see it be more congressional action, but we'll see how that plays out. The second thing that'll be even more interesting is there is a very strong rhetorical commitment to state deference to state flexibility all the way through these issues, including, so the question will be, does that actually get executed on? And it's a little bit like these executive power things where each new president is, this time around actually was the first time that both of the candidates didn't pledge that they were going to give up executive power. They always pledge it before the election, and then when they get in, they don't. Maybe Ford is an exception, but anyway, that whole thing is the same with the administrative side. They say, we're going to give power back to the states, and then they don't. But I would like to see that happen because, as I say, 10 years as an insurance regulator, 1 year in the federal agency, there's nothing that changed my mind about driving as much of the decision-making power as possible down to that local level. You should set some broad parameters at the federal level. So I would like to see that delegation back to the states. I don't know if it'll happen. And the most interesting thing to watch is the Republicans actually have a couple ideas that go directly against that. Interstate sale of insurance. If they do it like state up and the states get to opt into it and it's a compact, that's state power. If they do it the other way, which is we're going to force it down your throat from the federal side and we're going to say in every state you have to succumb to whatever some other state does and you don't even get an opt-out on it, that isn't state deference. That's federal imposition of federal power against the states through the mechanism of a single state. So we'll see how that one plays out, and the other one to watch on this is the pooling ideas. They're going back to these ideas of association health pools and all these things which, as an insurance regulator, you need to regulate your pools. You need to figure out how to get people into balanced pools. And if the federal government says you don't have any control over these association plans, one of the few issues that united all of the commissioners before we got to the partisan rancor of the ACA was we want power over our markets at the state level. And so we'll see whether they actually give more power to the states or do actually new forms of federal control over the states.
Joel, I'm waiting to see the first state insurance commissioner who says, they regulate insurance better in that other state than ours, so come on in. But we'll see. That's the theory of competition on that front. Dan?
Yeah, so it's interesting. I actually agree with a lot of your predictions. So we'll see. I do think they're moving towards using these risk pools as the way to deal with the pre-existing condition. At least that has the benefit of not increasing everybody else's premiums to pay for it. Is the notion behind it. The question is whether they'll fund it. I think to me the 64,000
insurance spreading to the insurers, which is a backdoor way of everybody paying for it.
Well, there is general.
Well,
revenue.
only because of the taxes now, right?
Yeah,
so
general fund, that's another way everybody pays for it.
Right, but right
different
now,
people
No,
pay
but
taxes than those who buy insurance.
maybe we shouldn't. There are some people who don't qualify for subsidies under the current exchanges, and those people are currently, if they're healthy, getting a bad deal, if you will. They're paying a lot more than they otherwise would in order to allow coverage for people with pre-existing conditions. The notion behind this idea of putting all those people in a separate high-risk risk pool is that those policies are always going to be very expensive. Taxpayers are going to have to subsidize it, but at least you have everybody else's policies a lot less expensive. People who are getting subsidies will be much less expensive to subsidize at the federal level, and then people who can afford it will just get a better price. I think the real question to me is when I've heard this question about continuous coverage, this is where I'm sort of struggling. I'm interested in your review of this. If continuous coverage is defined to mean that I do not have a pre-existing condition because I've been continuously covered, and for purposes of deciding that, the coverage I obtained on the exchanges counts, then essentially you're replicating this pool that's supposedly currently unsustainable. You're continuing that in place, and how you're going to get that to work and not in the risk pools. In other words, I'm not sure how that's going to work.
You can move from individual to it's HIPAA, basically extended to the individual market is the model.
Yeah, but I think
and you get to switch policies. Now, if you want to get into micro detail, which is the gritty part, it says you can't jump in 1 year from like a cheap policy to everything it's covered, and that's more administrative regulatory.
No, I understand
safeguards.
that, but if it's one thing to say if you had coverage before ACA and kept it going, that's one thing. The people who didn't have coverage because they had a pre-existing condition problem, but got it on the exchange, if those people are essentially considered as not having a pre-existing condition because they were continuously covered, I think that'll mess up the risk pool for the proposal. So I think
it's getting premium constantly from those people. So I mean, HIPAA actually worked. I mean, people who came out of group coverage knew if I don't do it within 60 days, I'm going to be out of luck.
And you
so
can add on if you go into the high-risk pool for, what do you want to say, 2 years? You just got your continuous coverage, and you don't stay in jail forever. So there are other refinements, but we don't talk about that at the high level. I understand.
The car swerving, I think, is a great analogy of the game of chicken. It'll be really interesting to see if the pressures right before the crash are going to be so huge. I wouldn't at all be surprised if one thing that ends up happening is they do away with the 60-day vote filibuster rule. If they
Altogether, you think they kill it altogether for everything?
If at that point there's no other way to get something through, and you're going to have millions of people get through, I'm not saying it's the right decision, and McConnell probably will be against this for institutional reasons, but they're going to be in a real bind, maybe, or else they extend it for a year.
If it
and they see
happens,
election.
it will be because of Obamacare. If we lose a filibuster, Obamacare will kill it.
Yes.
What people don't remember, the reason why Harry Reid triggered the nuclear option, because you had some D.C. Circuit judges make decisions affecting the ACA. He said, we need to do this to save the ACA for King v. Earl. Reid made that very explicit.
25 Democrats up in 2018, 10 of them from Trump states, 5 of them from states where Trump won by 20 points.
Yeah.
So there'll be a lot of pressure on some Democrats here.
And he may be able to make a deal.
Daniel.
Trump doesn't want to own health care any more than John Roberts wanted to own health care, which is why John Roberts wanted Obama to continue to own health care. The Republican Party needs to pass some sort of replacement legislation. I think Joel is right that it will look like delegation down. So if I were to predict, we won't have Trump care, we'll have McAuliffe care and Hogan care and Cuomo care and Brown care at the state level.
How about don't care?
Two big transitional questions. One, unless you get rid of the filibuster, you can't get rid of guaranteed issue and community rating through the reconciliation process. And what does the healthcare market look like if you have guaranteed issue, community rating, and you don't have the other legs of the stool? Second, the existing statute imposes a lot of HHS shall pay obligations that HHS hasn't been paying, and we're going to see more and more suits from health insurers against the government. If we stop the 1402 payments, if we stop the cost sharing reduction payments, we'll see a suit from health insurers under Section 1402. And then the question will be, does the Trump administration pay up? Right? A judgment creditor is a creditor, and if the government does not pay, its creditors, will markets treat that like a debt default? I don't know the answer to that, but that's going to be, I think, an important aspect of the transition.
All right, I did provide an exemption from Adam from the individual mandate to answer, but you have an option.
I was just going to say, my prediction ultimately is to agree with Joel on a very important point, because while history does have a couple of examples, mostly unfortunate examples of the president handing power back to Congress, the fact is Trump's going to love executive power, and he's going to be aided by a generation of conservative lawyers who, including some of my friends, some of the smartest lawyers I know, who will enter the Justice Department and resume their basic principled commitment in favor of executive power. I suspect the last 8 years will have taught them, if not nothing, next to nothing, and the Justice Department will be as committed to executive power as it was in the Bush and Obama years.
All right. Now, we do have microphones out there, and for those of you who've been very patient in the audience, tolerating my stand-up routine at the start as live audience, tell your friends to come early next time. But let's move over to this side. We'll start over here.
Thanks. Mike Miller. I'm a health policy physician. And Tom, I won't ask you if you got intellectual property authorization for using those 10 movie and music
That was the
clips.
reason it was before the live stream, and I did pay for the music, but we'll get into that later.
Not for commercial use, I don't think you
Tightly
did.
lawyered, but I could not get a court to decide.
My question is, if you could elaborate more on the timing about what happens if the cost-sharing reductions go away, either through dropping the appeal or an executive order or just a policy statement telling HHS or whoever stop paying those, and the insurance companies turn around and say, well, we're getting out. What's the timeline on that look like? Understanding that different states have other underlying rules about what their insurers can and cannot do. Can you spell that out for us, assuming it's a January 23rd proclamation or executive order or dropping the appeal? Thank you.
The appellate court has said yes to a motion by the House to come back in February 21st or some date like that, late February, to propose. They said we may be able to come to you with a solution that includes the Trump administration. So ball in the court of those guys. Obama tried to get control of the case. They rejected his motion and gave it to the House. So they have to come back with a solution. Once they come back with that solution, if that solution doesn't take care of CSRs for the next year, then that's when things start to go south. I'd be interested in what you guys think. No one will answer this question of what happens if their solution is the CSRs go south and they'd stop paying them. Does that take 1 month, 3 months, 6 months? How long does that take before it actually is implemented. But that end of February, we'll know what their solution is. And although it could be,
They
we need
could claim,
we need two
claim
more
victory
months
and
to
say
figure
they
it
won the
out.
constitutional point and now they're dealing with transitional issues.
Well, I see, but that's where I think it gets really tricky. There are various things you could do administratively and create, a 6-month period.
They might have put money in. You're right.
I'm not sure the appropriations clause and the Anti-Deficiency Act is one of them. If the money is not absent a congressional fix,
Turn off right away.
right away,
Immediately.
immediately. So
So March 1st, there are no CSR payments.
Whenever
There'll
that
be
check
something
has to
else.
sign.
You can still get money to insurers.
I mean,
You just have to find another
someone has to
spigot.
sign a check. Someone has to approve a payment.
Honestly, if I'm at HHS
Immediately.
or the treasurer, whoever's the responsible official, and I know I've got an incoming administration that says this is not appropriated,
Illegal.
I don't do it on January 21 without an OLC opinion because it's too risky.
There is an opinion that's never been released by some flack at OMB about why these payments are illegal. He's a Yale law grad, so it can't be that good. Sorry, I went to Mason.
I agree.
Don't the folks who are sorry.
No, go ahead.
Don't the folks who are actually represent health insurers here? So don't you then go sue on January 22nd in the Court of
Yes,
Federal
you
Claims?
immediately go to claims and let them sue, but that can take years.
I'm not sure you can.
I don't know if they get an injunction against this right away. I think
the
Tom's
Court of
point.
Claims have
Tom's point is more relevant, which is
If the
there.
money's not appropriated, I don't know, but we can go into this. This is intricacies of a judgment act. If the Congress
Tom-
deliberately has not appropriated money, I don't know that you can.
I always
get it
like
out
it
of
when
the
you say
Court of
Tom's
Claims.
point is
Yeah,
relevant.
Tom's
so-
point is more relevant, which is there are many ways to get money to insurers. The story I like to tell is in the Bush administration, when Medicare Advantage, its precursor, was in trouble, they went hat in hand to the Congress and to the president, and they figured out how to be so generous to the insurance companies that Medicare Advantage went on steroids. Obama came in and said, you guys were too generous. I'm trimming back what you gave to the insurance companies to stabilize their participation in this marketplace. Republicans said, you've trimmed it back too much, it's not going to work. It still works and it's still growing. So the Republicans are much better than the Democrats at giving things to the insurance industry if they want to. And if they want to here, they can do it.
And that's what deficits are for anyway. Let's take another question. Bill down front.
You may all agree on this. How about the insurer's liability for previous payments? I wanted to see if there's any agreement on that. Zero?
They won't touch them. Yeah. Technically, it was illegal. Was illegal in the past is illegal, but that's not going to be in play. I can't, unless anybody else thinks otherwise.
I mean, is there a false claim? Under what provision are you
Repay
recovering?
the money they received.
Yeah, but under what do you sue them for?
Well, they received all the cost-sharing subsidies the last.
You're talking about clawback, you mean?
Clawback, yeah.
Right, I mean,
yeah.
they got a check
Yeah.
from they got a check from Treasury. They cashed the check.
It was
I
illegal.
don't think they submitted a false claim. I don't know what you go after
You go
the insurer
quitam.
for.
Oh, I have researchers. You go quitam.
For what?
That would be
For
interesting,
accepting
Joel.
illegal payments.
But it wasn't.
There was nothing false about your claim. You were payable under.
They should have reasonably known that money was not appropriated. We can talk about this later.
No
well,
one's
that's-
going to
you-
press
you
the
answered my
issue, but
question.
it could be done.
Yeah, I'm probably not, but maybe they will challenge that. And that would affect whether the insurers want to even start a claim in the first place.
Who's going to bring the lawsuit? Well, you think
Yeah,
a quitam is the only way to do it. Yeah.
Standing's very hard. Let's say I've researched this, but standing's very difficult to actually bring that claim.
But let's remember one piece of reality here, right? Is no one wants to own it. It's going to be a massive headache.
Yeah.
People are going to, the Republicans are going to try to figure out some replacement. It's going to require cooperation from the insurance companies. The last thing they're going to do is that kind of nuclear option, sue or authorize
Right.
suit for clawbacks, because that's it. They'll never get any participation.
Yeah, I don't think the administration, but it might be somebody else.
Think about it this way.
Well,
If
but they're troublemakers.
If Hillary Clinton had been elected, everybody thought she's going to have a really tough road to figure out how to keep the insurers in this market. It's the weakest link of all the different federal marketplaces today. All the big companies want Medicaid, MCO business, they want Medicare Advantage business, they don't necessarily want the marketplaces. She was going to have to do a lot for them. Now Trump on top of that has to do all of that, plus whatever other uncertainty has been created for them. So if they want to say no to the insurers, it's not hard. They can easily drive all the insurers away. If they want to get them in, they've got some work to do. So we'll see whether they want to do that work.
And that's
Once
why,
again, we're talking about money and insurers. It never changes. It
and
just
that's
never
why if you're just trying to kill it, it's really simple.
It's
You're
easy.
right.
Every
you're
time
right,
I
you
write
can't-
about this, I have to say to the insurers, are you also going to have to pay back the money from the last 2 years? And it really affects Wall Street and the analysts and their
they won't
decision
do
whether to even go into
Nobody's gonna
March,
think
past
that's
March.
a-
No one's
Okay.
going to do it.
We're going to stay with questions. We're going to go to 11:30 until the last dog at least gets tired and stops howling. Let's go back there. We'll get around.
Hi, Paul Heldman with Heldman Simpson Partners. I follow health policy. On the cost, this is an excellent panel, by the way. On the cost-sharing subsidies, there was a little bit of interplay between Joel and one of the Daniels about what the insurers actually can do on the cost-sharing subsidies. Is there some clause in their contracts that would allow them to, in connection with this, to threaten to drop out in 2017? And if so, or if not, or do they have any other recourse in 2017 besides, as I know you mentioned, going to court? And then my other question is sort of about the practical aspects of this. We're going from one administration that expended a lot of energy trying to make this law work. We can argue about whether it was legally or illegally, trying to get people signed up. We're going to a new administration that's basically saying they don't like this law. So from a practical standpoint, what's going to happen to the marketplaces just because of that? Is there a likelihood that the enrollment erodes just because of the difference in attitude of the administrations and goals?
So far, the enrollment's basically on pace, so not an increase that some people would hope for because people are like, I better get in now because I'll be protected, but it's not going down either. On the first question, the clause is from the King v. Burwell time, and it says they can reopen the case, but it also says subject to other federal and state law. So it's a pretty vague clause, but I assume, and I think a lot of people do, that if they decide to cut off CSRs, it will be a deliberate decision. They will presumably then also intend to deal with the insurers in terms of relief, because otherwise the insurers are in the place of continuing to pay these out in terms of benefits without getting paid back. So I don't think there are too many insurers then. I think they might win the case in a year or two, but they're not going to really want to sit in the market, especially if some of their fellow insurers pull out, and then they're going to have a special enrollment period where they might get even more of the risk, and guess who would stay in and jump out at that point in terms of the risk pattern. So if they cut it off, those clauses probably will get activated, and then the state insurance commissioners will have something to say about it, but they can't compel those federal payments. So it will get very ugly very fast if they don't solve it.
Yeah, I mean, House versus Burwell had come out by the time the open enrollment had started last time and the policies were submitted, and my understanding is they all put in clauses like that. How quickly they could execute. Some of them are separately incorporated entities that will just go bust anyway, so it's academic. But I think that's what's going to happen. But that's why I described the cost sharing issue and the lawsuit not as a new opportunity for the administration, but a new headache. I think it's a massive ticking time bomb that hasn't yet really been fully thought through.
If the premiums go up in March, don't the 36B credits go up too in March?
They can't raise the
They can't raise
premiums.
premiums.
The premiums are, the regulation says premiums are set for the year, no premium increases mid-year. Now, there are people who think they can do an emergency action that gets around that, but that's what the statute says.
And what happens
I mean,
when
the
people don't
reg
pay their-
says.
What happens when people don't pay their premiums? Absolutely nothing.
That's
Well, no, they're out of, then they don't get the coverage.
Eventually.
That way. We didn't change all the
There are some people
laws.
who aren't getting subsidies,
Yeah.
and they agreed to a contract with a certain premium. You can't just say, okay, sorry, now something has changed, I'm raising your premium.
State insurance regulators in many states will hold the carriers to their promise to continue coverage all year, but it's kind of a hollow promise if, by the way, you've lost your tax credit in addition to your cost sharing reduction. So, there's not, it says a practical matter if the coverage gets cut off.
Tax credit cost legislation.
All right, well, speaking of cutting off, I noticed that these guys are actually billing me by the hour, so it's getting a little expensive. So I think we will conclude, but I want to remind you that as much as the lawyers talked about health policy today, the health policy people won't talk about the law, but we'll be back on Friday morning to talk about what might be ahead on the policy front here at AEI in another event we're organizing. So thank you very much for attending today, and please thank our panel.
Thank you, it was fun, yeah.